The High Court in Accra has dismissed an application by Bernard Mornah, the People's National Convention (PNC) flag bearer, to quash the Electoral Commission (EC's) decision to disqualify him from the 2024 presidential election. The presiding judge, Justice Richard Apietu, ruled that the PNC was not meticulous in completing its nomination forms, leading to Mornah's disqualification. Channel One News' Hansen Ajiman reports.
In his application, Bernard Mornah alleged that the EC violated his right to natural justice by not giving him an opportunity to correct the supposed errors on his nomination forms before disqualification. He claimed the commission initially notified him on September 13 of discrepancies in his form and asked him to rectify them. However, when Mornah resubmitted the form, he was disqualified without specific details of the errors or the chance to make further corrections. He argued that this action breached his political rights and his right to be heard, accusing the EC of violating principles of administrative justice. The EC responded that Mornah had failed to fully correct the identified errors, some of which were of criminal nature. One major reason cited was the absence of a signature for one John Arthur and the use of the same signature for 4 different persons endorsing the form. Justice Richard Apietu ruled that Mornah's right to be heard was not breached, noting that Mornah had been notified of the errors on September 13 and given the opportunity to correct them. The judge further explained that by failing to address all the discrepancies, Mornah essentially waived his right to be heard a second time. Justice Apietu also criticized the PNC and Mornah for their lack of diligence in filling out the forms, pointing to the party's long-standing participation in the electoral process since 1992. He remarked that with their experience, they should have been more careful and avoided the errors in the first place. Relying on the EC's claims that Mornah's form contained 4 identical signatures for 4 different individuals, raising concerns of potential fraud, Justice Apietu invoked the equity maxim, "He who comes to equity must come with clean hands," and dismissed the request for judicial review. After the ruling, Bernard Mornah described the decision as a travesty of justice.
The judge did not look at the issue that was brought to us, to it. It just went around. And I have already instructed my lawyers that this case is not ending here. We will go to the Supreme Court at the most, so that this matter will be determined. And that is why my lawyer said that they will quickly apply for the judgment based on the study. Of course, we just listen to it. We will study it critically. But I have already instructed them that we have to go to the Supreme Court, because I do not think that multi-party democracy should be jettisoned just from the corners of the Electoral Commission without our involvement. In the past elections, the Electoral Commission will sit down with the parliamentary and presidential candidates and point out what they think are the errors. In this instance, we are not even part of it. The Electoral Commission just sat somewhere, claimed that they have a technical and IT committees. Doesn't the PNC have an IT committee? Don't we have an IT person? So if the EC was determining issues of IT, then our IT person should have been there, so that they will be able to iron out the IT inadequacies that they are talking about. None of these things were brought to our attention, and then a judge will come and grant the wishes of the courts, the EC. We think that justice has been grossly traversed, and we will go to the Supreme Court.
His lawyer also expressed disagreement, stating that the ruling was not supported by the evidence presented in court.
First letter that was written on the 13th of September 2024 and addressed to Mr. Mornah was to the effect that there were errors on certain pages of the nomination forms. Now, they had identified those particulars in the 13th of September letter. Now, the forms were given back to our clients. They corrected them and resubmitted. The communication on the 20th of September, which was actually the reason for his disqualification, and I want you to get this difference. There was no particulars provided in that second letter of the 20th of September, which was the basis of Mr. Mornah's disqualification. So the 2 letters are not the same.
You disagree with the court when he says the 2 are the same?
Absolutely. Absolutely. And so if the court had come to the conclusion that the 2 letters were not the same, obviously the conclusion would have been different.